Thank you again for joining and welcome to another Questel webinar session. In this opportunity, we're going to be talking about trademark searches. We have titled this webinar, Beyond Clearance, a Smarter Approach to Trademark Search. And the motivation behind coming up with this topic to share with you guys today is that we have been noticing a wide array of attitudes towards what we consider to be a crucial pre-trademark registration step. And we thought it would be a good idea to try to compound all those different approaches into a more cohesive and structured message that you guys at the other end listening to this webinar and in this opportunity or a later stage, regardless of the entity that you represent, whether that is a large corporation, an established business, or if you're a startup, first filer, an NGO, or a governmental entity. If you're immersed in this activity and you're seeking proper counsel, you can use this as a sort of a playbook and demand that kind of deliverables from your provider, whether that is a company like the one I represent, a service provider, or your trusted attorney, such as the highly regarded guest that I have invited, and she has agreed to join me in this opportunity. And I'm going to introduce her in a little bit. So just to give you overview of the agenda and the topics that we're going to try to touch upon with my guest. So we're going to discuss why having a strategy is important in this field, how search methodologies have evolved, particularly due to the, of course, advancements in technology in this field, but also due to the enhanced complexities of global trade, such as the proliferation of online marketplaces, for example. How to assess quality when you are trying to tackle this matter, when you're receiving search reports from your provider. That might have a different meaning, a different connotation, depending on your needs, depending on your risk exposure, your industry, your company goals. We're going to touch upon those matters as well. Some of the challenges of not allocating the proper degree of relevance to this due diligence process and the cost of making wrong decisions in this regard. Some of the challenges that legal counsel, such as my guests, are constantly facing in trying to strike a balance between speed and accuracy and reliability. And of course, we cannot have a conversation concerning trends, and particularly with respect to the trademark world, without talking a little bit about AI and how AI has impacted this field of the trademark practice. But I'm not going to be the one sharing those insights myself. For that, I'm very delighted to have with me a French qualified trademark attorney. Her name is Ericka. Ericka, if you can introduce yourself, and don't be shy, don't be humble, talk about all your credentials and your experience for the audience, please.
Thank you, David, and thank you for the invitation today. So yes, I'm a French and European trademark attorney. I've worked in law firms, companies, and so I try to bring a business-oriented vision to my clients, in all their IP matters, especially trademarks and designs.
Awesome. Thank you so much again, Ericka, for agreeing to do that. And I'm going to pick Ericka's brain with some questions that I prepared for her. But before we do that, I want to set the stage for her and for you guys to have a little bit of background information on statistics that we have gathered here at Questel. And this is information that I have processed, that I wanted to put together for you guys to have an idea based on the types of orders, the amount of searches that we have been receiving from our clients for the past 3 years, you can see that there is a large preponderance of knockout searches. I think that is obvious, right? Because the first step that you want to achieve, and highly fast, I will say, is just to get rid of all those brand names and signs that face a clear and absolute obstacle, and you don't want to, entertain any further consideration for those. But you can see that there's not an insignificant number of what we call the deep screening searches. These are searches that are carried out by our experts in a house using AI tools and algorithm-driven tools, but they bring their expertise to provide a more nuanced legal threats analysis, taking into account all the different aspects of that might be relevant to your landscape, your industry, your competitors, whether there are complementary or substitute goods. So this is definitely more tailored and more business-oriented type of results. However, one piece of data that I want you guys to stop for a little bit to pay attention to is that still we have a 35% of what we call full availability searches. In case you're used to a different nomenclature or terminology, here we're talking about really comprehensive searches. However, there's an added value, which is that they contain a legal opinion from local lawyers or local experts. And this continues to be the golden standard in high priority regions such as the US, the UK, and China, and the EU. This is why I think it's really crucial to, and for me, very important to hear from Ericka's experience how she advises her clients on this regard. And then just one last note from information that we have collected from our latest IP industry outlook research that we carried out in 2025, for you just to have an idea on an investment priority shift that we have been noticing from our clients, from of course people in the industry, and 91% answer that they are using or planning to use AI when it comes to trademark search. So there's definitely all the focus on this part of the trademark life cycle, which I think it's paramount and it's important to pay attention to and dedicate enough attention and effort into making sure that it's catering to your needs. So before I turn to Ericka, just I wanted to ask a question to the audience. So let's start with the first poll. I'm going to give you guys a few seconds to answer this. And the question to you guys is, when conducting a trademark search or selecting a third-party provider to perform one, which factor is more important to you? So you have the options there. I'm going to give you guys a few seconds to answer this. Perfect. Then we can close the poll now. Awesome. So it's interesting to see the different attitudes towards this. So I think not to make the wait any longer, I want to turn now to Ericka. And let's start with the first question to you. How would you define a strategic trademark search today, as opposed to a purely clearance-focused search?
Well, I would say that a clearance search answers one question, which is, can we use this trademark without running into someone else's rights? It's a risk mitigation exercise at a specific point in time. Whereas a strategic search, in my view, goes further. It's a decision support tool that you use much earlier in the process ideally before the brand name is even finalized. In practice, you're not just scanning the register for identical or confusingly similar trademarks. You are mapping the competitive landscape, who owns what, in which classes, in which territories, how actively they enforce. And this way you can identify white spaces. You're flagging the signs that are inherently weak because they are descriptive or overcrowded, which of course affects not just the registrability, but the long-term enforceability of the sign. So the output is just a green, orange, or red light. It's a brief that helps the client makes better choices about the sign itself, about the filing strategy, about the storytelling maybe also around the sign, how they will use it in the future, and also about where to prioritize their budget. For me, I think that a strategic search is where the real value of a trademark attorney sits today.
Absolutely. I think that's a great perspective on how we need to start thinking, if not yet already there, implemented in your practice, to see trademark searches not just as a simple clearance exercise, as you mentioned, but also as an important business tool. And I think building on that evolution, I'm curious to see how clients themselves have changed over time. So let me ask you this: how has a client, in your perspective, a client expectation around speed, cost, and risk tolerance changed over the last 5 years?
Well, the tension between all this has increased very much. On one side, the time to market pressure has intensified, I would say. Product cycles are shorter, campaigns launch globally almost simultaneously, and clients expect search results in days, sometimes hours. And on the other side, the proliferation of automated search tools has created a price reference point that's very hard to argue against if you're not explaining your added value clearly. So what's interesting is that risk tolerance from the client's perspective hasn't actually increased. If anything, I believe it's even lower. And brand conflicts are more visible now. A cease and desist letter, a domain dispute, or a social media call out. These things, they escalate so quickly and publicly. It was not the case before, but now the reputational cost of getting it wrong has gone up, even as clients are sometimes reluctant to invest proportionally in the prevention of the conflict. So I believe that our mission as attorneys is to help clients understand that a 50 euros automated screening and a proper legal analysis are not the same product. The cost of a search is trivial compared to the cost of rebranding after a conflict or losing a filing you've invested in. And what I see is that the clients who've been through that experience, this very unfortunate experience, then they tend to become the most rigorous one afterwards on this topic.
Interesting. I think you highlighted a very interesting tension between faster decision making and also lower tolerance for risk, if at all. So on that note, let me ask you this: how do you communicate then nuanced likelihood of confusion, risk to business stakeholders who want maybe just a binary answer, yes or no, right? I need to make a decision. How do you do that?
Well, that is a great challenge. Because business stakeholders operate under time pressure and they need to make decisions. They want yes or no answers. But trademark risk is never that binary. Pretending it, I mean, it could be presumptuous for me. So what I think works best is trying to answer in a business-oriented manner. Instead of saying, okay, it's risky or it's fine, I try to translate the legal analysis into business language. For example, okay, there's a risk because there is a prior mark, but I think it's a moderate risk. The likelihood of confusion is here. Receiving an opposition is a real risk, but what we can also see is that the prior owner has a limited enforcement history. The marks are conceptually distinct. Therefore, the risk can even be considered as lower as initially evaluated. So my recommendation in the end would be, okay, let's proceed with the filing, but let's have a contingency plan ready in case it doesn't work. And such contingency plan could be, etc., etc., etc. This way, that gives the team something that is actionable. So I think this is a message that's easier to hear and to understand from the client's perspective than just a legal analysis saying, okay, there's a risk. And what I also think is very important is having a structured framework of risk, so low, medium, elevated, with an explanation of what each level means in practical terms. So, for example, probability of an opposition, likelihood of success if challenged, risk of refusal by the register, etc. That way, the business can make an informed decision, which is, I mean, ultimately, this is their prerogative. But my job is to make sure that they are not making any decision in the dark.
Well, I think that's a valuable reminder that trademark risk is rarely black and white, and I think that providing that level of guidance, of course, depends on the quality and the breadth of the information that we are reviewing. So I would like to ask you, how important are then non-traditional sources today? Domain names, app stores, marketplace listings, AI-generated content, even unregistered uses, as we see in common law countries as well. What do you think?
Well, that's very important, of course, because a registered trademark search alone is no longer sufficient for a thorough clearance. The reality is that the rights can exist and conflicts can arise outside the official registers. As you said, an unregistered mark used commercially can constitute prior right in many jurisdictions, particularly in common law countries. You also have to pay attention to unfair competition. A domain name also that has been active can be the basis of a successful opposition or a UDRP complaint. And of course, we must talk about AI, because AI-generated content is a newer dimension. But what about brand names or visual identities that are produced by AI and that inadvertently or not replicate existing marks? that raises still complex questions around origin and liability that the law hasn't fully resolved yet, so we must be extra cautious here. So I guess today a serious search has to be multi-layered, officially registers, of course, but also other sources, domain names, company names, and the new sources, I would say, social platforms, app stores, marketplace listing, um, and also targeted web searches. Um, it's more work for us, but it's the only way to give the most accurate picture to the client.
Yeah. No, yeah, I think it's clear that the scope of a proper search has expanded well beyond trademark registers alone, given that broader and more complex landscape that you have explained. Um, do so clients. This is to reinforce some of the notions that we were advancing at the beginning. So the clients increasingly expect faster and cheaper searches. So how do you preserve the quality while remaining commercially competitive? You also explained that now this part of the work is more labor intensive to you. So how do you justify this?
Well, I think you can't always have all three: fast, cheap, and thorough. So what you can do best is be transparent about the trade-offs and maybe offer a tiered service model. For example, for early stage screening, an automated search with a very brief legal overlay can be sufficient. It's a first filter. And if the name clears that stage, then you can invest in a more comprehensive analysis before filing. I think it is a sensible workflow that respects budget constraints without compromising the quality of the decision at the most critical moment. And on the quality side, I would say that technology has helped a lot. The right tools, properly configured and critically interpreted, allow you to cover more ground faster than it was possible years ago. I think it lies in interpretation. Interpretation is key because running a search can take just a few minutes sometimes, but understanding the results within the context of a specific market, of a specific client, taking into account the risk appetite of your client. That's work that cannot really be automated, I think. And I think this is exactly where you preserve quality. So commercially, I think we need to price the legal judgment and not the search itself. The search is more a commodity and the analysis is added value, I would say.
Yeah, you mentioned that technology, of course, can help improve efficiency, but I agree with you. I think that interpretation remains the real differentiator here. Um, so that leads to into a question that many of our clients are posing to us when we have conversations with them. Do in your opinion, do clients truly understand the difference between inexpensive automated searching and attorney-driven legal analysis?
Well, it depends. It depends. Some do and some others don't. And I think it's not their fault because when you have a platform that offers a comprehensive search for a flat fee of €50, it's not obvious to a non-specialist that what they're getting is just a database query without a legal interpretation attached. So the misunderstanding, from what I saw, often arises at the worst possible moments. It's when an opposition is filed or when a cease and desist letter arrives and the client says, okay, I checked and it was clear. But truly, what they checked was availability, but in a narrow sense. What they didn't get was an assessment of whether a phonetically similar mark in an adjacent class might be enforced by an aggressive owner, or whether the sign is inherently weak and thus will face examination issues. So part of our mission, I believe, is educational, and we need to explain clearly where the legal analysis adds value and where the consequences of skipping it can be severe. A rebranding exercise 6 months after launch is way more expensive than a proper search upfront. So I think that's a conversation that's worth having with our clients, even if it's regularly, but I think it's key here.
Absolutely. I think we have another poll question. Yes, to the audience. Um, so for you guys, what's the most challenging clearance situation you've encountered where the legal answer and business answer diverge? I'm gonna give you a few seconds. We can run the poll. I'm gonna give a few more seconds, guys. Perfect. Thank you so much for voting, and I think it's really interesting. That definitely paves the way for the next question that I want to ask Ericka about. All right. So with AI also becoming more sophisticated, I think it raises an interesting question um, where do you still believe human legal judgment is irreplaceable? You can uh, think of specific areas where you can help us understand this.
Well, several places. First, I would say contextual risk assessment, because an AI tool can flag visual or phonetic similarity between two marks, but what it can't reliably do is weigh that similarity against the enforcement behavior of the prior owner, the commercial context of the client's business, the sensitivity of the relevant consumer, and the likely attitude of a particular examiner or court. That requires judgment that is built from experience. And where I think that our legal judgment is also key is within strategic advice, knowing when to file despite the risk, when to modify a sign, how to modify the sign, when to seek a coexistence agreement, or when to challenge a prior mark. Those are security measures. Those are judgment calls that depend on factors that go well beyond the search results. I believe AI cannot do that, at least for now. So we'll see. And the third, and maybe the most important one, is communication. Because explaining a nuanced risk to a CEO or an artistic director who needs to make a decision in 48 hours, calibrating how much uncertainty to convey without creating paralysis on the client side. Well, I think it is a relational and communicative skill and not an AI one. So of course, AI is very good at processing information at scale, and it helps a lot. But legal judgment is not processing information at scale. For me, it's about knowing which information matters and why.
Yeah, I agree. I think that the most valuable contribution often comes, at least given the current state of AI development, not from the search itself, but from the strategic advice that follows. So that brings us to an area where I think legal input can also have a significant impact. Um, how early then do you think a trademark council should be integrated into brand development and marketing campaigns?
As soon as possible. Ideally at the naming stage, before any creative investment has been made. That's the ideal. And I think it's worth arguing for with clients who are tempted to treat trademark clearance as a final checkbox just before the launch of the product. And why is it so? It's because the cost of a name change increases exponentially the further along you are in the development process. If you discover a conflict at the concept stage, then you iterate on the name. If you discover it after packaging has been designed, a campaign has been shot, and pre-orders have been taken, then you have a crisis. So beyond risk avoidance, I guess that early integration allows counsel to contribute positively to the creative process. We can flag which types of signs are registrable, which aren't, advise on the strengths of a mark from a protection standpoint. We can identify territories where a name might have unintended connotation or legal complication. That is very important. So I think it is really useful for a brand team. It's not just a legal issue they have to deal with. So what I say is that I would like to see the client shift and say, okay, usually we clear the name we have chosen, but now we want you to help us choose a name that we can protect. For me, this is more like a partnership that leads to stronger rights afterwards on your names, on your visual brand identity, etc.
I really like that final point you made of convincing the client of moving from a clear name to helping them choose a protectable name. So for that collaboration to work effectively, I think we can skip this because we're running out of time. So I want to make sure you cover the last couple of questions in a comprehensive manner. So for that cooperation to work effectively, what information do you think it's needed from marketing teams to improve the quality of the clearance analysis for you guys?
Well, first, and obviously, I would say the intended goods and services, not just the formal niche classification they would like their search to be running. What I like is to have a real description of what the product is, what it does, who is it for, how it will be positioned on the market. Because in reality, two marks can coexist in the same class if the products are genuinely distinct or if they target a different audience. So this really helps us mitigate the theoretical risk, which can be very high at first sight. But then when we take into consideration all these more practical aspects of the project, the risk begins to lower. What also is quite interesting on our side to run an effective search is the target markets and the launch timelines. Knowing that a product launched in 6 jurisdictions simultaneously in 4 months clearly changes the search strategy compared to a phased rollout over several months. Thirdly, I would say that, of course, the visual identity and how the mark will be used as a word mark, as a logo, a combination, in which color, in different version, etc., is also very important. Because, of course, a name available in Word may raise different issues when combined with a specific visual used with a specific font or element. So this is another thing to take into consideration when you are analyzing the search results. And finally, I would say that what is really, really gold for us is any competitor intelligence the marketing team has. Because they often know the landscape, who the main players are, what names are associated with the category, and that context helps me focus the search and interpret results more accurately. So I would say that the more I understand the business reality behind the project, the better the legal analysis I can produce.
Yeah. I think that really underscores how trademark clearance is most effective when it's informed by this broader business and commercial context that you have mentioned. So one final question for you, and then I would also give you a few minutes for some closing statements if you would like to. But out of curiosity, how do you see trademark search services evolving over the next 5 years?
Well, of course, deeper integration of AI into the search processes. Well, as I said, I think it will not replace the legal analysis, but this will allow us to handle more of the mechanical work of coverage and similarity detection. It will allow us to go faster and more comprehensively than it is currently possible. So I think that the baseline scope of search will expand, and at the same time, the time required to perform the search will contract. And I think it is a genuine improvement for clients. And at the same time, I think that the legal judgment component will be more valued, because as automated search becomes a commodity, the market will increasingly distinguish between search as a product on one side and advice as a service. And I think that Counsel can articulate that distinction clearly and demonstrate the value of the analytical layer. The legal layer will be well positioned. The scope of what we consider relevant for clearance purposes will continue to expand, as already said earlier. AI-generated identities, new form of commercial presence, these are already rising. A question that existing frameworks weren't designed to answer before. So I think the search practice 5 years from now, we'll need to cover a landscape that's even more broad and more complex than what it already is today.
Absolutely. No, this has been great. All the insights that you have shared with us, Ericka. For you in the audience, if you had any doubt, if you were in the market for a proper legal counsel in Europe, there you have it. Which I failed to mention, by the way. And Novagraaf is a more than 130 years established law firm in Europe with presence in multiple countries in the European Union. So Ericka is a senior member of the firm, as you were able to witness. Um, Very proficient and highly technical with years of experience in this field. So it goes without saying, we're very thankful to having her sharing her opinions on this matter. If I could paraphrase in the last couple of minutes or to try to summarize some of the key takeaways from this conversation today, I'm not gonna read everything to you guys. We will share, of course, this presentation and the recordings either tomorrow or in a few days from now. But probably like one overarching lesson from today's discussion, I will say, is that trademark searches should not be perceived or viewed purely as a compliance exercise or a final checkpoint before the launch. I think the way Ericka was explaining to us, it is a strategic business tool that, when used early and effectively, can really help organizations build stronger marks to reduce risk and make more confident commercial decisions and build a more robust and protectable trademark portfolio. With that note, Ericka, is there anything else, any final comments you would like to share with us?
No, that's okay. Just a final thank you, David. That was a pleasure to discuss this matter with you and share our views. So thank you very much for this.
My pleasure. To the audience, thank you so much for joining. We have reached the end of the webinar. We look forward to having you again in the future. And on that note, we can wrap this up. Thank you so much and have a good rest of the day, wherever you are.
Thank you. Bye-bye.